All right, well, we might go ahead and get started here. I'm really thrilled to welcome all of you to the 2022 Dermot McGlinchey Lecture, which is also welcoming you to the 2020 Dermot McGlinchey Lecture and the 2021 Dermot McGlinchey Lecture, because things have intervened since this lecture was first scheduled, and we're thrilled to be in a position to at last convene to have this lecture and to be able to do it in person. So thank you all for being here. This lecture is one of the most important occasions in the intellectual life of this law school, and it celebrates a remarkable graduate of this law school whose legacy continues to shape all who pass through this building. Born in New York City, Dermot McGlinchey received his undergraduate and law degrees from Tulane, graduating in the Tulane law class of 1957. While a student here, he left his mark at this institution, both literally in the back of this very hall as a winner of our moot court competition during his time, and then figuratively through everything he did, both as a student and in the years since. For the next 36 years after graduating from Tulane, Mr. McGlinchey built a towering career in the private practice of law, and for all of those years he gave back to the law school, to the university, to the profession, and to the broader community. At Tulane, he served as president of the university's Alumni Association, and the university's highest alumni honor bears his name. And he also served the law school as chair of the law school's the development committee here at the law school that helped to raise funds to build this building, and vice chair of the endowment program for a maritime law center, and chair of the law school's building fund. So we are very much deeply in his debt every day. As a leader of the Louisiana Bar, Mr. McGlinchey was enormously generous and visionary in his support of access to legal services for all members of the community, and played the key role in helping to lead the Louisiana Bar Foundation in establishing the Pro Bono Project here. In 2016, we were very proud to induct Mr. McGlinchey into the Tulane Law School Hall of Fame, recognizing his stellar professional achievements and his wide-ranging service and leadership on behalf of Tulane and the community. The lecture that we hold today reflects yet another important legacy, another dimension of his legacy, because it was created and endowed by his partners and colleagues at the McGlinchey Stafford firm he helped to found and build into one of the nation's great firms. Founded in 1974, the McGlinchey Stafford firm now boasts hundreds of lawyers. I've stopped counting because it continues to grow, spanning 15 offices now in 11 states by my most recent count. So it's a story of phenomenal success. And after Mr. McGlinchey's all too early passing in 1993 at the age of 60, his partners founded this lecture series in his honor through the firm's charitable foundation. And as I say, since that time, it has grown into being one of the most significant events at our school, drawing some of the nation's leading scholars and practitioners and judges to this podium. Today, we're thrilled to continue that tradition with a very distinguished scholar, Professor Linda Maclean, who's also a friend and colleague in the field and sometimes collaborator. And we're pleased to welcome virtually her collaborator, co-author, and husband, Professor James Fleming, as well. Finally, I just want to take the opportunity to acknowledge and thank and invite you to join me in thanking members of the McGlinchey family who are here with us today, including Deirdre McGlinchey, member of the Tulane Law School class of 1995, and a partner at the McGlinchey firm. and her husband and Tulane Law classmate, Hal Moffett. Also very pleased to welcome back Fanula McGlinchey Monstead, a member of the Newcomb class of 1990, and her husband Charles, and as well as welcoming back other members and leaders of the McGlinchey firm. So please join me in thanking the McGlinchey family and firm for their support and in welcoming Professor McClain. I will turn the podium over to my colleague Steve Griffin to introduce our guest.
Thanks very much, Dean Meyer, and thanks to all of you for being here. I kind of echo what the dean said. It's just kind of unfortunate. I'll just, make a footnote, as I say in class, that we had to wait 2 years to hear from Professors McClain and Fleming, and due to kind of unfortunate circumstances, Jim isn't with us physically, but he is listening in, and he will be present, as we say, on Zoom for the question and answer period at the end of the lecture. It's been my custom just to speak extemporaneously on maybe something about why I chose this now not speaker but set of speakers, and just refer you to the very impressive biographies. The thing that got me to think of the idea of inviting sort of a dual lectureship was a wonderful lecture that both of them put together in the wake of the same-sex marriage case, Obergefell, which is now a number of years ago, but which certainly a complicated case, but rendered much easier to understand by the combination of their unique talents. Perhaps Professor Fleming is a little more on the side of constitutional theory. They're both very interested in and expert on constitutional law. And Professor McClain, with her expertise in family law, feminist legal theory, often brings what I consider to be kind of a unique perspective and a very insightful perspective on issues that are treated more doctrinally in constitutional law. So I really wanted the combination of them here, but I'm very happy that Linda's with us. I just point out to you that they already have teamed up on a really great book called Ordered Liberty, Rights, Responsibilities, and Virtues in 2013. I hope they'll team up again. And I wanted to point out that they both have just a really impressive scholarly record. Professor Fleming's about to come out with a book, Constructing Basic Liberties. And we were going to celebrate 2 years ago the recent publication of Professor McClain's book, Who's the Bigot? But who cares that it's been 2 years? We can celebrate it as if it was yesterday. That's all right. So without further ado, I'd like to introduce Professor Fleming, the Robert Kemp Professor of Law at Boston University. Please welcome her.
Okay, I'm just going to set my timer. Okay. I'm so thrilled to be here, and as Steve said, we were originally going to deliver this lecture 2 years ago, and of course the pandemic intervened. Our topic, though, is still very relevant in its civic education in polarized times, and in some sense it's even more urgent today than in March 2020, since the murder of George Floyd in May 2020, the greater prominence of the Black Lives Matter movement and the backlash against it, and the insurrection of January 6th, 2021. We are so thrilled to be giving this Dermot S. McGlinchey Lecture on Federal Litigation, because there's certainly plenty of state and federal litigation around this topic of civic education going on right now. Clearly, from David's introduction, he had a remarkable career as a civic-minded lawyer dedicated to equal access to the courts and justice under law. We appreciate the law firm endowing the lecture series, and we're honored by the presence of his daughters, Fanula and Deirdre, and their spouses. So Jim and I have had the good fortune to know Steve and learn from him for many years. We won't say how many. And we appreciate his invitation as well as the hospitality And I very much enjoyed walking around your beautiful campus this afternoon, because we're not quite that far along with spring in Boston. You might be wondering what our title means, and so let me unpack it a bit for you. Appropriately, we have a flag right here in the corner. In West Virginia State Board of Education versus Barnett, the Supreme Court struck down a compulsory flag salute in public schools. Jehovah's Witness children had refused to salute the flag on the ground that there was an interpretation of the Bible that they thought meant they would violate their religious convictions if they did so, and the penalty was expulsion from school. Justice Jackson's majority opinion protecting their First Amendment right not to be compelled to affirm a belief may be the most eloquent, stirring, and revered opinion in constitutional law. It's certainly the most quotable, and as Jim likes to tell his constitutional law students, reading Barnett's a bit like reading Shakespeare. You constantly come across passages that you've seen quoted or alluded to repeatedly. One such passage is Justice Jackson's declaration. The first thing you see here, and the title of our lecture comes from this, that if there's any fixed star in our constitutional constellation, it's that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. This passage prohibiting governmental coercion of what shall be orthodox has been frequently invoked in culture war controversies over education curriculum over the decades, most recently in support of state laws banning schools from teaching about racism and sexism in particular ways, and particularly, as you've probably heard many times by now, banning critical race theory from being taught in the schools. Likewise, business owners objecting on religious grounds to providing wedding-related goods and services to same-sex couples have invoked Barnett in the right to be free from compelled orthodoxy and challenge state anti-discrimination laws that prohibit discrimination on the basis of sexual orientation, arguing that to provide these goods and services would compel their speech or their creative expression. The Supreme Court recently granted cert on a new case coming out of Colorado involving website designer Lori Smith. I'm going to confine my lecture to the civic education example, but I can talk about the second example in Q&A if you're interested. So one common link between these examples is the Christian advocacy group Alliance Defending Freedom is representing challengers in both areas. So we argue in this lecture that to keep the fixed star from becoming an exploding star in these culture war battles, we should interpret Barnett in context, including the court's less frequently quoted words that to promote national unity and appreciation of our institutions and ideals, government, quote, may require teaching by instruction and study, close quote, about history, civics, constitutions, and the guarantee of civil liberty. And to frame our analysis, we also invoke two of Justice Jackson's famous formulations in other cases also from the 1940s. The first is his dissent from the infamous Korematsu versus United States, where the court upheld the internment of Japanese Americans in euphemistically termed relocation centers during World War II. Jackson lamented that the court had violated a principle of racial discrimination, predicting that the principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. The second quotation is from another First Amendment case, his dissent in Terminianello versus City of Chicago from 1949, where the court, applying an absolutist conception of the First Amendment, protected a demagogic Catholic priest freedom to give an inflammatory anti-Semitic and anti-communist speech which incited a turbulent crowd outside to riot. Jackson stressed the relationship between order and liberty and cautioned that if the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact. Many celebrated Jackson's opinions for their eloquence. We hope to emulate his practical wisdom in grappling with controversies over patriotism and discrimination in circumstances of diversity and disagreement. We argue that some judges, scholars, legislators, and litigants have extended Barnett's principles by doctrinaire logic beyond where Jackson's practical wisdom would have taken them. In fact, many are using Barnett's principles like a loaded weapon to eviscerate or end vital civic education programs and salutary anti-discrimination laws aimed at securing the status of equal citizenship for all. Furthermore, conservatives like Justice Thomas have overextended Barnett's principles to advance a libertarian deregulatory conception of the First Amendment, a development that would likely cause a confirmed New Dealer and champion of the regulatory state like Justice Jackson to turn over in his grave. I'll begin by situating the battles over Barnett amidst larger debates about the condition of our constitutional system. Many have feared that the U.S. is in the throes of a constitutional crisis, or worse yet, constitutional failure. Jack Balkin, a former lecturer in your series, has observed that democratic republics like the United States are especially susceptible to what he calls rot. He quotes Benjamin Franklin, whose statue I saw yesterday at the courthouse area, a famous line from Benjamin Franklin answering the question of what form of government the Constitution establishes: a republic if you can keep it. This line highlights that keeping a democratic republic requires maintenance, lest it rot or even die. As a partial remedy for mitigating or overcoming such rot, we argue for the imperative need for the renewal of the civic character of people themselves as capable, responsible members of a well-functioning constitutional democracy, striving through critical reflection and deliberation to live up to our ideals. Now, in a previous essay addressing Balkin's work, we gave an example of the kind of civic education that is not the answer. The 1776 report issued in 2021, January, by President Trump's advisory 1776 commission. Although President Biden swiftly disbanded the commission and withdrew the report's approach to what it called patriotic education warrants attention. It attacks identity politics and critical race theory in particular as incompatible with American principles and authentic civics education by teaching young people to hate our country. Such attacks find echoes in the spate of proposed or enacted state and local laws prescribing whether and how teachers may teach students about racism and sexism, including, in some instances, teaching what I'll call CRT for critical race theory. Indeed, CRT has become a new boogeyman for people unwilling to acknowledge our country's racist history and how it impacts the present. We believe a more promising model is the call for reflective patriotism and excellence in history and civics set out in the Educating for American Democracy initiative announced in early 2021. That model embodies love of country with clear-eyed wisdom about our successes and failures in order to chart our path forward. Recognizing that the constitutional order has become more democratic over time because of the efforts of social movements, for example, this model seeks to educate young people to participate and sustain our constitutional democracy in order, invoking the language of the Constitution's preamble, to make our union more perfect. The roadmap for the Educating for American Democracy initiative offers an inquiry-based approach organized by themes and questions, leaving room for diversity and perspective and stressing civil disagreement as well as civic friendship. Teachers help students engage with hard histories of inclusion and exclusion, histories of oppression and power, and how individuals and groups use agency in the face of oppression and work to expand constitutional and civil rights. So in this lecture, I'll talk about the role Barnett is playing in these current culture war battles over models of teaching history and civic education. Because even though President Biden revoked the executive order in which Trump established the 1776 commission, that same order identified a list of 9 divisive concepts, which could not be used in any workplace training by government contractors or promoted in any federal funded program. And these continue to shape proposed or enacted state laws restricting what may be taught in schools, even though a federal district court even before Biden's rescission of the order, issued a nationwide preliminary injunction against the executive order because the divisive concepts part was unconstitutionally vague. And you just look at some of these, you'll see maybe why the court thought they were vague in terms of teachers not knowing what they could safely teach and not teach in the classroom. One concept that's gotten a lot of attention that has been instantiated into some state laws is the notion that a banned concept is any individual should feel discomfort, guilt, anguish, or any other form of psychological distress on account of his race or sex, okay? Another is the notion that one race or sex is inherently superior to another race or sex. I had the great pleasure to participate in a Zoom conference in which Steve was also involved in the last few days, and the prominent political scientist Roger Smith, who's involved in the Educating for Democracy mission, pointed out to me that this concept might ban some favorite conservative sheroes from being taught, like Phyllis Schlafly, who opposed the Equal Rights Amendment because she really believed women were morally superior to men. So this divisive concepts, it's very hard to know in all the directions it could go. But in any event, to give you some examples, the Oklahoma legislature enacted 8 of these concepts in HB 1775 in 2021, restricting how race and gender may be taught in K through 12 schools and in higher education. New Hampshire enacted 5 of them and simply engrafted it onto their existing anti-discrimination law. So in New Hampshire, it's not just race or sex, it's any protected category, and kind of disability, age. And so, for example, you're not supposed to treat someone with respect to race or sex. What about reasonable accommodation for persons with disabilities? Is that banned? Is that a banned concept? Or what about senior citizens being eligible for certain kind of programs? I mean, so it raises a whole bunch of questions. Okay. Not to wander into too much hot water here, but I understand in Louisiana, Representative Garofalo introduced a bill to ban these divisive concepts in K through 12 schools and post-secondary education, adding a few additional ones such as the concepts of capitalism, free markets, or working for a private party in exchange for wages are racist and sexist or oppress a given race or sex, but the bill stalled. I'm eager to learn more from you about this, but it's clear that civics and history remain controversial in Louisiana as elsewhere. Earlier this month, the Board of Elementary and Secondary Education adopted new K through 12 standards for social studies after a lengthy comment period with a flood of parental comments about how students should be taught about race as well as Louisiana's racial history. And press coverage stressed that it was a freedom framework that excluded critical race theory instruction. A number of the authors of the standards have already disavowed them for not being progressive enough or adequately preparing students by including historical perspectives. Okay. So turning now to what Barnett said about governmental promotion of national unity, civic virtues and capacities, and the equal citizen status of equal citizenship for all. I'll talk about several distinctions Jackson drew and several practices that the court explicitly or implicitly indicated government may use to promote national unity and appreciation of our institutions and ideals, and how conservatives today are obliterating or eliding some of these distinctions. Jackson stressed that the case involved a clash between Jehovah's Witnesses' right and the authority of the state, not a clash of rights with others. And in today's anti-discrimination cases, for example, there is a direct clash between the rights of LGBTQ persons to equality through protection from discrimination and the religious opponent's right to religious liberty. Jackson also stressed that Jehovah's Witnesses' disobedience was harmless to others and posed no danger to the state's pursuit of its end, national unity. And also that they were a small and widely despised minority who'd been subject to nationwide attacks for their views and actions. In the context of anti-discrimination law battles about protecting on the basis of sexual orientation, the dissenters are nearly half the population. Until recently, their views were the dominant ones throughout most of recorded human history. This is true even though grievance conservatives like Justices Scalia, Alito, and Thomas claim conservative Christians are subject to animus and charges of bigotry. So what did Jackson mean in saying that government may not prescribe what shall be orthodox? What does Barnett permit? Certainly, Jackson does not mean that government must be neutral between competing ideals, say between white supremacy and racial equality, or between patriarchy and gender equality, or between constitutional government and totalitarian government. In other words, the government may not promote the public values of the Constitution. Barnett was written in the context of a war against an actual totalitarian government, but Jackson did not say that government must be neutral between our nation's ideals of liberty and equality on the one hand, and totalitarian domination, oppression, or genocide on the other. And he was not making the claim that what differentiates our democracy from such totalitarian government is that our government must be neutral. He was talking about the means that one may use to promote certain national ideals. Thus, when he says government may not prescribe what shall be orthodox, he means they may not compel or coerce people to affirm an orthodoxy they reject. He doesn't mean prescribe in the weaker sense of recommending or attempting to persuade people of the value of certain national ideals or commitment. He pointedly says government may compel students to do many things in the school setting, and the state may require teaching by instruction and study of all in our history and in the structure and organization of our government, including the guarantees of civil liberty, which tend to inspire patriotism and love of country. He distinguishes this means, what he calls this slow and easily neglected route of civic education, from the shortcut that substitutes a compulsory flag salute and a pledge of allegiance. We believe civic education should encourage reflection on our constitutional ideals and aspirations, acknowledge where our historical practices have fallen short of realizing them, and educate concerning past social movements that have successfully redeemed the promise of these ideals and aspirations. By comparison, the 1776 report and other efforts it's inspired has a concept of patriotic education that demonizes those who criticize the past and present practices and seek to redeem our nation's promises as rooted not in reflective patriotism, but hatred of country and anti-Americanism. In 2020, after the summer of multiracial and multi-generational protest in support of Black Lives Matter, this was an important time of reckoning and reflection. And in some states, those protests led to efforts to expand commitment to education about diversity, equity, and inclusion, including by initiating new programs or strengthening existing ones. But some of those initiatives then triggered backlash and cries that CRT was being taught in the schools. Many of those resisting or rejecting that reckoning are now taking the shortcut of banning schools from teaching about race. And since Dr. Ibram Kendi is so often the target of so many criticisms about CRT, I should mention that one thing BU did, where I teach, is start a new Center for Anti-Racism Research headed by Dr. Kendi, and I have the honor of serving under Dean Onwaki Willig, who is the first chair in the nation in critical race theory. So BU is really the center of a lot of this. Okay, so for example, in Oklahoma, after students met with school officials to discuss their experiences with racial and ethnic identity in schools and call for greater exposure to diverse voices and ideas in the school curriculum, educators took steps to teach about the past and present experiences and inequities faced by historically marginalized students. Such inclusive speech would include culturally responsive curricula or culturally responsive teaching. Now, if you're an educator, you probably know there's something called culturally responsive teaching, CRT. It has often been confused and conflated with critical race theory. So these are all kind of mushed together in this big thing that people are against. Cogent rationales for such inclusive speech were, in the words of one student council member, we need a better curriculum to teach people the mistakes of our past and how we can do better going forward. In other words, reflective patriotism. But as would be the case with some other school districts, these fortified commitments to equity and diversity were actually in keeping with existing state directives that school curricula reflect the racial, ethnic, religious, and cultural diversity of the United States and reinforce critical thinking by evaluating challenging ideas and assumptions. Nonetheless, as a complaint filed in federal district court in Oklahoma by students, teachers, and various civil rights groups alleges, the Oklahoma legislature drafted a bill to target and censor these inclusive speech programs and instead enacted verbatim prohibitions on nearly all the divisive concepts of the Trump executive order. And a comment by one Republican legislator illustrates the perceived stakes. We are in a fight for the future of our children and grandchildren. Critical race theory proscribes a revolutionary program that would overturn principles of the Declaration of Independence and destroy the remaining structure of the Constitution. Another describes CRT as a poison to the mind of our kids. Notably, while not citing Barnett specifically, the complaint argues that the First Amendment doesn't tolerate laws that cast a pall of orthodoxy over the classroom and chills academic freedom. And as do similar complaints against other state bans, this complaint enlists other Supreme Court precedents characterizing America's public schools as the nurseries of democracy, and the classroom is peculiarly the marketplace of ideas. They also cite to Brown versus Board of Education on the crucial role of schools as a principal instrument to awaken the child to cultural values, to prepare the child for later professional training, and to help the child access education equally, affecting their ability to study, engage in discussion, and exchange views with other students. So among the risk of these bans, just to go back to these concepts again, is that they chill any teaching that seeks to impart knowledge of and thinking about the history or current manifestations of racism in the United States. For example, the 1776 report and many of these state proposals frequently quote Dr. Martin Luther King's vision of racial justice in service of a colorblind constitution, and they associate affirmative action or analyses that bring out systemic racism with anti-Americanism. So a teacher might seek to encourage students to reflect on King's legacy and unfinished business, but fear that they would be charged with violating these laws. And in fact, in the New Hampshire complaint, they said that while the teachings of Martin Luther King have been commonly taught in New Hampshire schools for more than 50 years since his assassination, under the new law, they could only be taught as historical relics with no application to present-day society or participants' personal experiences. So think about it. The one in green is the one everybody loves to quote, right? Just by the content of our character, not the color of the skin. But what about these other concepts? Would these be divisive concepts that are banned, where King acknowledges the embeddedness of the concept of supremacy in white society, or that whites have not made much of an effort to re-educate themselves out of their racial ignorance? It's an aspect of their sense of superiority that white people believe so little. That sounds like a concept that one race is superior to the other. So you see some of the issues that this raises. Now, the African American Policy Forum, Truth Be Told campaign, helpfully dispels some of the myths reflected in this divisive concepts list that have fueled so many of these state laws. For example, emphasizing that concepts like structural racism, implicit bias, and intersectionality do not state that white people are inherently racist or men are inherently sexist. Instead, they provide frameworks and tools to engage governments, systems, and individuals about how policies and practices work to disadvantage and harm racially marginalized population. Of course, any attempt by schools to compel affirmation of particular opinions on these subjects would run afoul of Barnett, but we need to be clear-headed here about a pedagogic exercise compelling an orthodoxy versus an exercise encouraging reflection upon and judgment concerning competing views about racism in this country. Suppose a high school civics teacher required students read an excerpt from Dr. Kennedy's book, How to Be an Anti-Racist. This in itself would not compel a student to affirm a belief that they're racist. Suppose the same teacher had a student read an excerpt from a different book, hypothetically called Racism in the U.S. is a Thing of the Past. This would not compel a student to affirm a belief that there is no racism in the U.S. today. Or suppose a teacher required every student to write an essay summarizing and assessing the views of both of these excerpts. These would not be problematic under Barnett, for they don't compel what shall be orthodox. But to ban these exercises would be a shortcut to a misguided form of patriotic education. It would blinker reflection on our past and present practices involving racial injustice and block, quote, the slow and easily neglected route to understandings that might motivate the hard work necessary to make progress toward racial justice. And I should say, some conservative speech codes even ban any reference to social justice, saying it's a code word for CRT. So we might imagine a continuum of distinctions under Barnett. Compulsion of opinion, clearly unconstitutional. But compulsion of curriculum, including civic education and study of U.S. history, would be permissible, as would reading and stating facts, and encouraging through persuasion and example. A practice that's likely to be divisive and probably provoke bashlight might still be permitted by Barnett unless it's compelling speech. And we fear that some conservative states, in reacting against this boogeyman of critical race theory, which has become kind of a proxy for everything people are fearful about concerning racism in America, have elided these distinctions between points on the continuum, claiming that they are all compelling government unorthodoxy or unconstitutional under Barnett. To be sure, there are some examples in some of these lawsuits criticizing school curricula trying to teach more affirmatively about racism that may go too far. The most commonly cited example is a case brought in Las Vegas that you may have read about, in which a biracial student objected to exercises required in the Sociology of Change course and received a failing grade of D-, which imperiled his ability to graduate from high school. His mother, who is black, alleged that the curriculum directed her son to unlearn the basic Judeo-Christian principles she imparted to him, such as the proposition that every person is unique and equal in the eyes of God, and this doesn't sound like something I read in the Bible, it sounds like Dr. King, be judged by the content of their character rather than the color of their skin. But in any event, you know, if you read the case and you read what they allege, it does sound a bit like it might cross the line. And he objected to doing the exercise, saying it would make him make public affirmations about his racial, sexual identity and gender identity that he believed to be false. Apparently, students had to label themselves and then reflect on what part of their identity had privilege attached and which part had oppression attached, and they defined some of the things like privilege was the inherent belief in the inferior of the oppressed group, and people who qualified oppressors and who in virtue of their gender and race harbored inherent belief in the inferiority of others. So be that as it may. I mean, this, I think this is an example of an exercise that probably crossed the line. It's also unfortunate that the school administrators were so inflexible about any kind of accommodation, given, as the complaint pointed out, that the school, Democracy Prep, encouraged students to feel empowered to use their voice to stand up for what's right, even if it meant pushing back against a school policy. The case settled after a federal district court stated that Clark was likely to succeed on the merits since the speech was likely compelled, and reportedly the school expunged his grade and allowed him to opt out of the course so he could graduate. There are some other examples that recur in complaints against some of these curricula that are trying to be more inclusive, like making students participate in privilege lines where they take one step forward or one step back, but there's many practices that don't, right? I mean, one of the complaints, the educators complaining that in a diversity education and inclusion training, they had to watch a video about the Black Lives Matter movement. I mean, that is not compelled orthodoxy. That is simply exposure to perspective, right? Or they had to learn about concepts like white supremacy or systemic racism. Even the Manhattan Institute, which is out there championing model laws to limit critical race theory, admits that there's some compulsion that's permitted in public schools, such as there's right and wrong answers on tests, so they may compel student speech, and schools have broad authority to make curricular decisions. And in Barnett itself, as the continuum suggests, Justice Jackson contemplated that government may compel students to state facts, including facts which in their opinion ought not to be true. For example, on a civics exam, if a student was asked, does the Constitution of the U.S., as presently interpreted by the Supreme Court, protect the right of same-sex couples to marry? We heard about Obergefell in the introduction. To receive credit, a student has to answer yes, even if they personally believe that Obergefell was wrongly decided and that such unions are not recognized as by God as true marriages. Thus, even though some students and their parents might object to such a question as compelling an orthodoxy, their claim would not be supported by Barnett. One of the problems is that in our polarized times, many people treat facts simply as other people's opinions and treat their own opinions as facts. And there's a Mark Twain quote about that somewhere. So Jackson also observes that although government may not foster national unity by compelling a flag salute and a Pledge of Allegiance, it may promote national unity by persuasion and example. Jackson states, to believe that patriotism will not flourish if patriotic ceremonies are voluntary and spontaneous instead of a compulsory routine is to make an unflattering estimate of the appeal of our institutions to free minds. But he leaves no doubt that government may try to persuade students on the appeal of our institutions and ideals to free minds. So not by banning teaching that's critical of the nation for its failure to live up to its commitment to the principles that all persons are created equal, but through teaching that despite our nation's shortcomings, we the people have striven gradually and not without vigorous and tenacious resistance more fully to honor that commitment over time. Or government might try to exhort students that working to fulfill our commitment to equality is a better course than learning about pervasive injustices and becoming disillusioned, cynical, and inert. Now, such persuasion certainly can't work when some states in these bans also prohibit students from offering credit for internships working for social justice, as some have. A teacher might assign a book or article about people who recognize pervasive injustice, including systemic racism, and became active in the civil rights movement. For example, they could read, students could read not only about Mildred Jeter and Richard Loving, the interracial couple at the heart of Loving versus Virginia, but they could also read about Bernard Cohen and Philip Hirschkopf, the young Jewish attorneys with the ACLU who represented them in successfully challenging Virginia's law. They could even assign the Barnett opinion. Constitutional law scholar and now Princeton's president, Chris Eisgruber, has perceptively argued that in Barnett, the court is acting as an educative institution, teaching lessons about American identity as being bound up with living up to what the stars in our constitutional constellation stand for, and exhorting us to live up to that identity. That conception of our identity stems from reflective patriotism rather than a love it or leave it tribalism. Barnett's lesson is that we should be reflective patriots whose love of country is based on free and fearless reasoning of intellect and spirit. We should not be forced to become know-nothing patriots who are protected by book banning from the discomfort of confronting injustices. Now, even though proponents of patriotic education today invoke Barnett and their battles against liberal or progressive anti-racist civic education, we should reflect what side of the controversy they would likely have been on in the 1940s. Recall how President Trump responded when NFL players were kneeling rather than standing during the national anthem at the start of football games to protest police brutality and racial inequality in the U.S., and how many conservative commentators supported his view. He implored the NFL to coerce players to stand during the national anthem, forbid them from playing if they kneeled, and even to fire the players for kneeling. So Jackson cautioned that public education, including compulsory civic education, should be faithful to the idea of secular instruction and political neutrality. And he said, if it is, it will not be partisan or enemy of any class, creed, party, or factions. Now, in the culture wars, conservatives often cry that teaching about race in ways that liberals or progressives urge is not politically neutral. But typically, they wrongly claim or assume that not teaching about race or teaching about it the way they advocate is politically neutral. That is, teaching there is systemic racism or implicit bias is partisan, but teaching that racism is simply a matter of bad hearts, bad apples, individual bad actors and malevolent hearts is neutral. A favorite text here is to say that Justice Harlan's statement in dissent in Plessy versus Ferguson that the Constitution is colorblind is the neutral position, and therefore any taking race into account, for example, affirmative action or other steps to remedy ongoing racism, is suspect. But this supposed neutral position is one of two primary competing interpretations of the Equal Protection Clause. The other, the anti-caste principle, also is embodied in Harlan's famous dissent in Plessy. The colorblind view should not be enshrined as an orthodoxy. So we firmly believe that in circumstances of strong polarization, it's imperative to teach the conflicts, not just to teach one side or the other, as if one side is neutral in the American way and the other side is anti-American indoctrination. We think that we agree with Justice Jackson that we should be able to teach without fear that freedom to be intellectually and spiritually diverse, or even contrary, will disintegrate the social organization. And in another much quoted statement, Jackson said, freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. We believe it's prudent to teach the conflicts and cultivate virtues and capacities that enable students to hear multiple perspectives and make judgments about which views to adopt. Refusing to teach the conflicts stunts the development of civic virtues and capacities needed for life in our diverse, contested, polarized constitutional democracy. Such civic education helps to equip people for forms of democratic participation, including participation in social movements necessary to the health of constitutional democracy. It aspires to cultivate civic virtues and help develop capacities for responsible constitutional self-government, such as tolerance and respect for others who are different from ourselves, mutual forbearance and trust, norms on which republics depend. We've heard so much about a breakdown of trust in the United States. A disposition and capacity to give reasons rather than merely make assertions. And also civic education should aim to develop substantive knowledge and civic skills, as well as a set of dispositions and capacities to learn about and critically reflect upon the history of the United States and its basic texts, ideals, and principles, as well as the shortfall between commitment and practices, and to engage in critical reflection about what type of policies and programs are needed to promote our ideals. And also, a rebooted civic education for the 21st century needs to teach media literacy to help young people be discerning consumers of news and responsible users of social media. And we all know the terrible problem of propaganda and how it contributes to dividing and confusing people and drives polarization. Now, I have very little time left, so I'm just going to say that it's a formidable challenge. Even though civic education is a perennial concern of various national commissions and summits, it's often hard to imagine a way forward in our scheme of federalism, given not only regional diversity over the what and how of civic education, but also growing polarization. For example, when the Biden Education Department announced new priorities for American history and civics education that would in effect support culturally responsive teaching to incorporate practices reflecting the diversities, identities, histories, contributions, and experiences of all students to create inclusive, supportive, and identity-safe learning environments, Missouri's Attorney General claimed that this would unlawfully and unconstitutionally fund initiatives that fund racial discrimination and conflict with recognizing America as unique and a city on a hill. And South Dakota's governor forbade any education departments in South Dakota to get any federal funds until the legislature could pass a law protecting against these types of Biden initiatives. So the stakes are high and are in times of polarization. Okay, I'm going to stop this now. Okay, in times of polarization. So whoops, stop. Okay, so in conclusion, sorry, I don't know how to stop my clock. Okay, okay, be quiet. Okay, in conclusion, I'll just say that our view is that we're not trying to prescribe a full program here, but we believe, to go back to our parallel to Shakespeare, that the fault is not in our stars, including our fixed stars, but in ourselves, and that we should not let Jackson's fixed star in our constitutional constellation become an exploding star that turns the Bill of Rights into a suicide pact, accelerating strong polarization into secession or constitutional rot into constitutional failure. Thank you. I'm going to turn that off so Jim can be.
Oh, yeah.
Yes, we can get Jim up here as well.
Okay.
All right. We have a very nice reception for you, but it's been our custom to ask for some questions, a few questions after the lecture.
There's Jim with the ghost of Lochner, if you know anything about him. One of the students gave him.
I see, it's the ghost.
It's the ghost of
The ghost of
Lochner,
Lochner.
yeah, that haunts constitutional.
If anyone had a question of this very thoughtful presentation, thank you again for coming. But, that's Rowan, right?
Yes.
See, I got one student right. Remember one name, sorry.
So this goes a little bit less to civic education, but is tangentially related and goes to free speech. I'm not sure if you are aware of the recent situation at Yale Law School where the ADF was there to give a lecture and there were student protesters there, after which a federal judge sent out an email to federal judges across the country encouraging a closer look at students who engage in these protests. And so I don't know if my 1L fears are misplaced, but I worry that if the free speech of protesters is limited in their ability to go get clerkships and things like that for federal judges, how that might contribute to the constitutional issues that you discussed today.
Yeah, Alliance, I mean, Jim actually has followed them more closely, but the Alliance Defending Freedom, I mean, you know, the Federalist Society keeps bringing them through for these talks, and obviously that's going to inflame people and get them very upset, given all the causes that ADF has supported. Jim, do you have anything you want to say about that?
He needs to unmute.
Oh, how do you,
He can unmute.
oh, Jim, unmute.
Okay. Yes, I think that I don't know enough facts to determine whether the students were any more disruptive of order at Yale than, say, the Black Lives Matter protesters were disruptive of order in cities all across the country. So I don't know whether Judge Silverman's reaction is an overreaction against legitimate protest, just as I think a lot of the backlash against Black Lives Matter was an overreaction against legitimate protests. But it would be unfortunate if students who felt like they were addressing important political and constitutional matters of the day were blackballed from federal clerkships because of a conservative justice's emails.
was really terrific. And but the focus of your lecture was on the First Amendment and whether the First Amendment would be a barrier to curriculum or other measures to instruct. And I wondered, drawing on your other related expertise in constitutional law and family law, whether you might comment on the claims about parental rights,
Okay.
Given that that's been another strand of argumentation in Virginia and elsewhere about parents' rights.
Yeah. Yeah, okay, so one, in the interest of time, I left off part of my discussion of that Nevada case. So clearly, one of the most fundamental liberties, as David has written about, is the rights of parents to direct the lives of their children and direct their children's education. However, states also have authority over children's education. It's kind of a dual authority, and parents don't have a constitutional right to dictate the school curriculum. Now, they can get elected to school boards, which is part of what's happening now, is getting people on school boards so they can determine curriculum. But it's not enough for a parent just to say, I don't like what the schools are teaching because it conflicts with my beliefs. There's complicated issues of whether parents have a right to opt their children out of certain diversity, equity and inclusion curriculum, just like there's been past cases about, religious parents thought that the curriculum was subverting gender roles because it showed a girl reading a recipe to a boy while the boy cooked, and this would subvert traditional gender roles. So, I mean, it's a good question, and I think that parents certainly do have fundamental liberty, but they don't have a right that there be congruence between their religious beliefs and the public school curriculum. And parents have voted with their feet by choosing private education, by choosing homeschooling, and picking lots of different ways to evade the sort of public school curriculum. But again, the question is, should there be opt-out or accommodation? This comes up with sex ed curriculum, for example. Yeah.
All right, well, I hope you'll join me in thanking Professor McClain again, and thank you, Jim, as well.